Good afternoon, everyone. My name is Bill Nicolai. I am your moderator today for the workshop and webinar on dealing with disruptive employees. My clock says it's 1 o'clock, so let's get started. It is being presented by our mentor at our Indianapolis SCORE chapter, Dennis Dunlap, who's a retired human resources vice president with over 35 years experience in this area. I will be hosting and being your moderator. We encourage everyone to ask questions through the chat function. We're not sure if the question and answers button is working, so let's best work through the chat function. I'll be moderating those. And while we're waiting for everyone to get settled, I remind you that you can find this as well as many other resources on our indianapolis.score.org website or on the national website, score.org, which includes many links to finding mentors' experience in many professional areas. Surveys show that businesses who use mentors have an over 70% chance of success as compared to only 50% chance of success for those companies that don't use mentors. We will give you those website addresses a little bit later, and feel free to ask. You will receive copies of Dennis's slide after the presentation. It might take a day or two for you to receive those, but do feel free to ask questions through the chat function, and we will be taking time throughout the presentation to answer questions throughout the workshop. We have allotted 90 minutes for our workshop, but we don't expect all the time to be taken, so ask all the questions that you wish. I look forward to hearing Dennis's insights. And Dennis, sir, feel free to start.
Hey, thanks, Bill. Well, I want to welcome you to our afternoon workshop here this afternoon. We're going to cover 4 topics this afternoon. We're going to start off with dealing with disruptive employees, move on to workplace bullying, talk about illegal harassment other than sexual harassment, and then sexual harassment itself. The goal today is to give you an understanding of how these 4 topics can tie together in today's workplace. All 4 are very sensitive topics and can cause emotional as well as financial issues for employers, regardless of your size. We'll begin with dealing with challenging or disruptive employees. And by not dealing with these employees with the first sign of disruptive behavior, this can lead to bigger problems as time passes and the issues escalate. It can lead to bullying type behavior, illegal harassment, as well as sexual harassment. First, a disruptive employee. How to address the behavior, get to the cause of the problem, document the situation. We'll move on to bullying and the various types of bullying. Because bullying is not always about yelling and screaming. Next, we'll cover illegal harassment and what constitutes the various forms of harassment. And then we'll close with sexual harassment and your responsibilities as the employer. But before we begin, I just want to cover a couple of details here again. Whoops.
Hey, Dennis. I got a note saying that you're cutting in and out.
Really?
So you may need to speak into your microphone.
Let me get a little closer then. Thank you.
That might help.
Slight accident here. Just bear with me. Let me get out of this. Oh boy. My notebook fell on the. There we go. Okay. Okay. How's the volume now?
Better.
Okay, good. Okay. So let me just move forward here. Okay. So let's talk about dealing with disruptive employees. Many organizations face the task of having to deal and manage with disruptive employees. Supervising other people is never easy, and some employees make it particularly difficult. You should be prepared to deal with workers who complain, goof off, spread rumors, and display anger. It's important to deal with these problem behaviors before they get out of hand. When you have a disagreement with a disruptive employee, the impact can be felt throughout the company. Your disruptive worker may ignore your message, make it tough for you to lead, and ensure continued productivity so it does not spread and affect other employees. And of course, the question always comes up, why not fire the employee? Bill, is everything okay? I can't hear you. Okay. Bill, I can't hear you.
Make it on a slideshow. Make it full screen on the slideshow.
Oh, I'm sorry.
It went back. And there was one comment. Yeah, make sure you stay close to your microphone.
There we go. Okay. So, what we want to deal with this afternoon, 4 topics in this segment. Understand how important it is to manage yourself, those conflict issues, how to respond to employees, documenting the incident, and finally the written document. And I want to emphasize how important documenting the incident is with these individuals because it is important. People do get mad occasionally, but the way an employee handles the anger can affect everyone. There's no room in the workplace for an employee who has frequent outbursts of anger. I try to find the cause of the anger, and of course, remember, keep yourself calm under the whole situation. If the situation doesn't improve, you may have to take disciplinary action. And of course, you always have the responsibility as an employer to provide a safe and healthy work environment. The first step in dealing with a difficult employee is managing yourself and keeping your own emotions in check. Here are some points to keep in mind when dealing with difficult workers. First and foremost, remain in control. Staying calm under these kinds of circumstances can be a great help in dealing with a difficult worker. It's assessing the situation. What has occurred to get to this stage? And deciding what can be done. And sometimes it's good to take a step back and decide what you can do to help the situation. Often there are some issues, perhaps even outside of work, that is causing the negative behavior. Some common problems.
Dennis?
Yes.
The panelists are still having trouble hearing you. So I don't know if you have earbuds or you can pull your computer closer to you because they're saying that they can hear me fine, but they're still having difficulties hearing you.
How is this? I mean, I'm trying to speak as loud as I can without shouting, Bill. Was that okay?
I think so, yes. Give it a shot.
Okay, I'll just talk a little louder. I can do that. Okay. Common problems. I have the word attitude up there for a reason. Be careful of using that word attitude because we want to focus on behavior. Because when we talk about attitude, the employee says, hey, my attitude is fine. Your attitude's the problem, and you're off on a whole different conversation. Focus on the behaviors and what is happening with that employee. Is it attendance? Why? Is it failure to get the job done? What are the issues there? And of course, it's always someone else's fault. It's never my fault. I did my job, they didn't do theirs. So again, we're trying to keep the focus on behavior, not attitude. We talk about some of the conflict issues. First of all, we're talking about expectations. Performance problems may occur when a supervisor and employee have a lack of agreement about what those expectations are. Be sure you have clear expectations. Is it a skills issue? Do they have the required knowledge, skills, and competencies to perform the job? If not, perhaps there's some additional training that's needed. And of course, there's always the issue of workplace conflict. Conflict with a supervisor or coworker may result in a decline in performance. Why does that conflict exist? We talk about 3 areas: age, gender, and race. 3 very common topics that we're hearing a lot about in these last few weeks. Age. Some companies have 3 generations in the workforce. You can put a 20, 30, 40, 50, and 60-year-old on the same team, and you have very different perspectives of how the work should be done. There's gender, and of course, race, as we've seen in the last several weeks, the issues with gender and race. Understand where that conflict is coming from and what's the cause. Health problems. Particularly if you have an older workforce, you may be dealing with some health problems. Understand what those are and are there accommodations that need to be made. And of course, there's always the issue of personal or family issues, particularly as we've had to deal with this COVID pandemic over the last several months. Again, what are those conflict issues? Okay, we're responding to the employee. First, it's important to take the complaint seriously. Is this a serious situation or is this just another gripe session? It may be a serious issue that needs attention. So it's important to listen to what's being said and also how it's being said. Is there a level of intent voice that just very both? Asking open-ended questions. Why the employee did something, why they said something. Understand that this could be a possibility. It's also important, don't get personal. Keep your discussion objective and focused on the issues of the situation. Telling the employee what your expectations are and have some form of agreement so you can get to the solution. So now they understand expectations. And of course, don't let it go on and on and on. Get to the cause, get it solved, and move on. That's what's important here, so it doesn't drag on. Also, in dealing with employees, what's their history? Is this the first time it's happened, or there have been previous incidents? And how long have those previous incidents been occurring? What are you trying to get across to that employee in terms of what your expectations are again? Perhaps there's a need to establish a baseline. There were unclear expectations, and so there were problems. Okay, here's where we are today, and here's how we're going forward, because we've got agreement on expectations. So you establish that baseline. What's done is done. Let's move forward, and here's what the expectations are. And again, looking at those causes, the skill sets, the need for training, resources, and standards. Understand those issues. And again, be sure you understand, is it a can't do or won't do situation? Those can be important in dealing with these issues. It's also important to explain your concerns, using statements that will help calmly discuss the disruptive behavior. You're staying calm, you're staying objective. Perhaps offering suggestions to change the behavior and be open to the employee's ideas. The employee's been late completing assignment. Why? The employee could make perhaps better use of their time and his or her time. And again, avoid the personal criticism. Don't blame or criticize the employee personally. We're trying to stay focused on the subject and don't get sidetracked. Consistency. Again, understand the consistency that's involved here, because employees have a good general idea of what has happened in the past. So we're trying to focus on what's being said and how they're stating their concerns. Your role in management. First and foremost, do you have enough information to substantiate the performance or behavior issue? Are there other employees involved? There may be employees on the team. There may be employees in another department who are also having an impact or being impacted. Be sure you get this done in a timely manner. Don't let it drag on. Get it done, get agreement, and move forward. Of course, it's important, again, that you enforce these rules or standards if they're involved here on a consistent basis, particularly with policy violations or standards violations. Be consistent. And if there is action to be taken, does it fit what's occurred? Particularly if it's a first-time employee, first-time incident, as opposed to an employee who's had these issues in the past. And of course, what are going to be your next step as you go through this? I want to spend some time on the written document. These are important because, again, it's all this stuff in writing. And sometimes I know it's a difficult task and it's time consuming, and we all have better things to do than just write things out. But it's important to outline each area that needs to improve. A brief history. Again, has there been previous coaching or counseling involved with this individual? You want to have specific examples of employees' behavior. And of course, you want that data to be accurate in terms of dates, times, others involved. It's important to write out these details because this prevents a common ailment that I've encountered over the years. It's called selective amnesia. Because the employee says, hey, I don't remember it was this way being done. I don't remember having that discussion. No, you've got it all in writing of what's taken place. I mean, I've seen selective amnesia take place a year later, 6 months later, and even a month later. I don't remember it that way. You've got it in writing. So you have all that down in terms of accurate data and dates, times, others involved. It's important. And again, is there a policy violation, and what is that policy? Another thing to consider in the written document, the employee's version. You may include that in the write-up. And again, this can go a long way as far as history. Again, you're evaluating behavior, keeping it focused on the behavior, how it's impacted the organization, the business reason for taking action. All those things are important because we're trying to keep it objective and keep it focused on behaviors and actions. The employee sign-off is also important because now the employees sign and acknowledge what has taken place. They may refuse, but you can get around that. You can note that on the write-up that the employee refused to sign the document. You sign it, that they were given a copy, and you have a witness sign it. Just the fact that the employee doesn't sign it doesn't make it invalid. You've taken all the action you can, and you do it that way. So, in the document, you also want any corrective action to be taken and the timeline for that action. Are you going to follow up in a couple of weeks, a month, a week? What is that timeline going to be? And what are those actions that have to take place by that timeline? But you have expectations going forward and what you want to see accomplished. Are there consequences if the employee issues are not resolved? Having a timeline for follow-up and feedback. And again, what happens if this occurs again? If this is a final warning, make it a final warning. Giving someone 3 final warnings, you're going to lose credibility. Many years ago, I was involved in an arbitration case where the employee got, I think, 5 final warnings. And the arbitrator says, you don't have a final warning process, case dismissed, and we lost. If you're giving a final warning, make sure it is the final warning, and that's it. So we have that in the document. So, summarizing what we've just covered here in the last few minutes. It's so important to address disruptive behavior early on because failure to do so can cause more serious issues in the future. Employees like this can cost you lower productivity, they can cost you morale, they can be very costly to the organization. And most important, this is unacceptable behavior for the workplace. Okay. We're going to take a moment now for any questions or comments. So, Bill, any questions or comments at this point in time?
No, Dennis, I've completed all the chat questions, so I think we're doing okay.
Okay, we'll move on then. Okay, let's talk a little bit about workplace bullying. So we reviewed the importance of dealing with a disruptive employee and resolving those issues. Again, not dealing with them can lead to more serious issues, particularly such as bullying. So let's move on to it. So however it's defined, and we're going to see a number of definitions on workplace bullying and see that it does not always include yelling, screaming, or fits of rage. In fact, it usually takes place in a much quieter scale in the form of exhibiting unwarranted criticism, intimidation, blaming someone without facts, unfairly singling someone out, spreading rumors. So who are the bullies? It may not come as a surprise that women are often the victims of workplace bullying, but some people may not realize that the majority of bullies are also female. In fact, according to the results of a recent workplace bullying survey, 68% of reported cases involved women on women bullying. So it can involve everybody in your workforce. And again, the issue here is we have a continuing prevalence of workplace bullying and its harmful effects. And so our point here is for employers to know how to recognize, confront, and stop bullying as soon as it occurs. So what we're going to cover in this segment, talk about the definitions of workplace bullying, the various forms of workplace bullying, the difference between workplace bullying and illegal harassment, because we'll see that not all bullying is subject to federal or state legislation, the impact it can have, and ways to confront bullying in the workplace. So, some definitions. Workplace bullying and trauma institute. Repeated mistreatment. Malicious mix of humiliation. Intimidation. This is more common than sexual harassment or verbal abuse. And the key here in this last one, deliberate, repeated. All those things that are happening to employees driven by one who has that desire to control. So again, it's not always about the yelling and screaming, as we'll see in these definitions. The actions can include intimidation, demeaning work standards, not giving another employee credit, perhaps setting them up for failure, and constantly reminding them of old mistakes. Threatening their personal self-esteem and work status. Isolating employees from opportunities or interaction with others. And particularly with team leaders or supervisors, giving impossible deadlines, undue pressure and stress, and overworking employees. All these can become part of workplace bullying. So the various other forms it takes. The constant and unfair criticism. Employees using phrases like, you're always behind schedule. You never get it right the first time. There's that constantly directed at employees and perhaps even in front of others. The same with social bantering and teasing. Sure, we all kind of tease one another once in a while. And if you're a diehard Cubs fan like me, you've been teased a lot. But that doesn't mean it's bullying behavior. It's when it's, teasing in front of others. And of course, yeah, you got yelling, shouting, and screaming. The insults, behind the back put down, the hostile glares, the body language, other intimidating gestures. These are all forms of workplace bullying, particularly the body language, because no one hears that. We also talk about gossip. Yeah, gossip sometimes can be harmless, but it can also be vicious, particularly when it refers to an individual personal situation. Perhaps something about their family, their marriage, whatever. And as you know, sometimes gossip gets embellished as it moves on down the line. Monopolizing supplies and other resources. And of course, we see a lot in the workplace today with all the aggressive emails and texting and other notes. That aggressive email, that's all in caps and about a 44 font, yelling and screaming at others. And of course, overt threats and aggression and violence. And going back to the emails and texting, What's your policy on the use of company emails in terms of using for this type of behavior? It should be something that you want to consider if you have an email policy. So we have to understand the difference between workplace bullying and illegal harassment. And we'll get into illegal harassment in the next segment. It's inappropriate and unacceptable behavior, but it's not always prohibited by any federal or state law. However, it may result in a hostile work environment, but that hostile work environment is not the same as created as we get into sexual harassment and pornographic photos or other objects. It's not the same, but you can have some workplace bullying issues when it comes to hostile work environment. The impact to your organization, because if it's not confronted and stopped, it can have an effect on employees in terms of anxiety, depression, headaches, poor concentration. You really want someone on the job who's not totally concentrated on their job. That can have an impact on your productivity. It can have an impact on your bottom line. So understanding that workplace bullying can lead to those personal issues, and they can become very serious as time. The cost to you as an employer, and of course that very first one is a big one, increased turnover. I'm sure some of you are having difficulty hiring and finding good employees. And the last thing you need is turnover, particularly when you've got a good employee who has now become the victim of workplace bullying. It can lead to higher healthcare costs if you have a healthcare plan. More doctor's visits, more tests, more lab tests, whatever. And certainly low productivity, something none of us need in the workplace today. And of course, there's absenteeism. It's been a good weekend, and I just dread going to work on Monday morning. I'm calling in sick. Or it's Friday. I've had a really bad week because I've been bullied. I'm not going in today. Absenteeism can really skyrocket when it comes to bullying. You also have the issue of retaliation, where it may reach levels that someone's going to fight back. Someone just said, I've had enough, and is going to pick something up and knock down another employee. And now you've got a very serious issue on your hands. So again, not addressing it can cause these issues. And of course, bullying makes it almost impossible for employees to reach the goal of treating employees with respect. You want to be known as a good place to work. And bullying is going to have a serious impact on them. People want to come to work and enjoy themselves, do their job, go home. They don't want to come to work scared to death. So again, it can have that kind of an impact on your organization as you're going through this. Some other points to consider when we get into bullying, and here's where we can get into some legal issues. If it's pervasive enough, continuing, and considered threatening, creating a hostile work environment, you can have the potential claim for constructive discharge, intentional infliction of emotional distress, or relating bullying to a protected class of discrimination. Constructive discharge. Very simply put, constructive discharge is a situation where an employee is forced to resign because they just can't take it anymore. However, while it could be a claim, the burden of proof is on the employee to show that there was an issue. She or she took that issue to management. Management didn't do anything about it, and the behavior continued, and he or she was forced to resign. That's constructive discharge in the very short term, but it can be a case that you could face. Bullying, to a protected class discrimination. Older workers are the ones always subject to bullying. Women are always subject to bullying. So now you've got a protected class discrimination issue on your hands. So again, while it may not be illegal on the surface, it can lead to these issues, which again could cause you some difficulties in the court. The ways to confront it. Okay. We're going to talk about policies as we go through all three of these segments here on in illegal harassment and sexual harassment. Have an anti-bullying policy of what it is and that it's unacceptable behavior. It's educating your managers and employees about your position on the policy. Having a process to report it, how you're going to investigate it, and how it's going to be resolved. And it's important that if there is a case, to periodically check with employees to see if it does exist and is not being reported. Management by wandering around, just going out among your workforce and talking to people. But again, as we talk about the policy, we're also going to talk about that with illegal harassment as well as sexual harassment and tie it up at the end where you can either have one complete policy or separate policies. It's up to you as an organization. But it's important to have an anti-bullying policy that may even, be part of your workplace violence policy. But it's important to have that, and again, educating managers and employees about your position on it. So to summarize this section, again, bullying can have some serious and harmful effects on you. We talked about the number of forms of bullying, and again, paying attention to the fact that it's not always about yelling and screaming. Those subtle body language moves, the isolation, some of the things that we talked about. Again, it's not always about yelling and screaming. Important that you address it immediately. And people understand that you're going to address it immediately. And again, while it's not always illegal, it's still unacceptable in the workplace. Okay, Bill, any questions or comments at this point?
Dennis, we're all good.
Okay, all right. Okay, our third segment is talking about illegal harassment. We're not going to talk about sexual harassment until the fourth segment. We're going to talk here about illegal harassment. And as we've seen, bullying behaviors may not constitute unlawful harassment. It's basically essentially unwelcome behavior. We want to move now to illegal harassment and then close out our workshop discussion with sexual harassment. What we're going to cover in this segment, we're going to talk about what illegal harassment is, harassment versus inappropriate conduct, ways to prevent it, the categories, and these are important, and then the federal laws that prohibit illegal harassment, particularly in those categories. Again, talking about your policy and procedure and what your responsibilities are as management of your organization. Okay. We often hear the word harassment and we think only harassment based on sex. But there are illegal harassment under federal laws that can occur and based, as you see there on the bullet points, all those points: race, religion, national origin, age, disability, all of those, military veteran status, even sexual orientation and gender identity or expression. So all of these have coverage under federal laws, and we'll go through these as we go through the sexual and illegal harassment. But first of all, what's definition? Again, severe, pervasive, or continuous, persistent conduct, interfering with an employee's work performance and creating that hostile work environment. You're going to hear that term a lot these days. It's kind of the most common form of harassment, hostile work environment. Some are legitimate, some are not. But again, it's important. The second bullet's important in terms of where the occurrence can impact an employee's status or benefits where they're affected by the harassing conduct of a manager or person of authority. So this can be a part of also illegal harassment. And of course, adverse employment activities, actions, retaliation. And we're going to spend some time on retaliation when we get to the segment on sexual harassment. But again, retaliation is a critical issue, and sometimes the more costly action that's taken when you have a harassment case. So what we're going to talk about here is harassment as it refers to an illegal form of discrimination. Now, a lot of employees say they've been harassed. Maybe they've just been subject to inappropriate behavior or conduct, or maybe just someone in a moment of frustration said or did something and they're being harassed. Well, let's keep it in perspective. These can be sometimes are described as workplace bullying, and sometimes based on a legally protected status. But again, while all harassment is not illegal, again, no form of harassment should be acceptable in your workplace. Why it's important. Certainly, harassment can impact every employee. It should be part of your company values that you want to ensure that all employees are treated with respect. You want to be known as a good place to work. Sure, you've got the pay and benefits and all that good stuff, but again, you have a good place to work. People want to come there and they want to stay there because it's a good place to work. And of course, it's important that you're complying with all federal and state discrimination laws and fair employment laws. You want to be in compliance. There could be some liability as an employer under federal or state law or even civil litigation. The fourth point is an important one. A company is always responsible for any form of harassment by a supervisor or a manager that has an impact on a tangible employment action or benefit, hiring, firing, promotion, change in pay. That is always a company's responsibility when that harassment action has an impact on a tangible employment benefit. So let's go into the various categories. First of all, we talk about race and color. The slurs, the jokes, derogatory comments, any kind of verbal or physical contact based on an employee's race or color constitute harassment. It creates, again, a hostile work environment and prohibits an employee from performing his or her job. You're having an impact on their employment, whether it's performance on the job or creating a hostile work environment. It impacts that, and that's what you want to avoid. We talk about religion. Employees ridiculed because of his or her religious beliefs. Another type of harassment occurs when a coworker or a supervisor preaches to an employee about their religion and why it's so beneficial for them to join their religion. And that employee perceives, key word there, perceives. That's how they see it. And to them, this is reality. A case where perception is reality. The behavior is unwanted, offensive, and again, creates that hostile work environment. It impacts their ability to do their job, and may even impact, their pay or benefits. And certainly, with religious harassment, there's that reasonable accommodation to accommodate an employee's, religious beliefs, unless doing so, as it says, would impose an undue hardship on the business. Reasonable accommodation still comes in here with the religion. Military status. USERA, which covers reinstatement rights for all individuals who are involved in military and job against an employee because of their military status or obligations. National Guard. Classic example, the weekend drills on Saturday and Sunday, which means they can't work overtime. And so you can't take action against them because of that military status. And of course, you've got the 2 weeks of summer camp. They're gone for 2 weeks. You may have to hire a temp. You may have to have others work overtime. You can't take any action against them because of their military status. And we'll talk about that as we get into the laws here in just a moment. Okay, let's talk about the federal laws. A series of them here. Title VII of the Civil Rights Act of 1964. This is the granddaddy of all the laws that have come into play. 15 or more employees. Prohibits having discrimination based on all the categories you see there. Race, color, religion, orientation, gender identity, pregnancy, national origin. Employer has to have 15 or more employees. You may have less than 15 employees, but from a practical viewpoint, you don't want this happening in your workplace because you still face civil litigation. Even though it's 15 employees, you could still be subject to a lawsuit when it comes to sexual, discrimination issues. ADA, the Americans with Disabilities Act, as amended, and that's an important point as amended. 15 or more employees protects individuals with disabilities and those regardless having disabilities. As amended, affects a lot of people. I am basically disabled under ADA because I am a cancer survivor, and I am considered disabled under the amended Americans with Disabilities Act. So you have to understand that it's not just someone that, as you can physically see, has a disability. It's different and other ailments that can come into play. Immigration Reform and Control, 3 or more employees. This is the I-9, and that's why it's so important for employers to have an accurate and complete I-9 form filled out by everyone that they hire. Because you have undocumented individuals, you can be in trouble. And also what's important with the I-9, that the I-9 is kept in an entirely separate file. It does not go into the employee's personnel file. It's considered to be part of a separate file. So be sure you have a personnel file and an I-9 file. All the I-9s of all your employees are in that file and not in the personnel file. Age Discrimination and Employment Act, 3 or more employees, over 40. Protects individuals there. And of course, USERRA protects employers regardless of the number of employees. So there's no minimum here. Against discrimination against employees, applicants, on the basis of their military status or military obligation. That's what those are important for. A couple more here. We have the Civil Rights Act of 1991. Again, 15 or more employees. And here, it also gets into what's called disparate impact actions. Now, disparate impact is a term that's used where a company may have a very neutral policy about hiring or reduction in force. But if it has a disparate impact on a minority group or protected class, it can be considered illegal. The case in point here goes back on the Supreme Court cases. Briggs versus Duke Power. Duke Power in 1971 in North Carolina had a labor pool. The labor pool was all blacks. To get out of the labor pool and get into other positions, you had to have a high school diploma or a GED. That was standard across the entire company. But it had a disparate impact on blacks because in 1971 in North Carolina, you had a lot of blacks that did not have a high school diploma. The Supreme Court said that's a disparate impact and it's intentional and it's employment discrimination. GINA, Genetic Information Non-Discrimination Act, 15 or more employees. It prevents discrimination against employees because of their genetic conditions or genetic information. You cannot request genetic information on any individual. And you can't base, any kind of hiring or firing based on their genetic information. So, let's get to your company policy on illegal harassment. Again, policy that explains what forms of illegal harassment are covered. Again, we talk about this, but sexual harassment, where you can find the two. Educating and training managers and all our employees on your policies. They understand what your policies are and what the issues are. Process for multiple sources of reporting. Because many cases in illegal harassment, when the policies were first written, if you have an issue, report to your supervisor. Well, supervisors were the ones who were doing it. So the EOC required multiple sources for reporting. How a complaint and investigation will be handled. So it's all in writing. And again, you can combine this with your policy on sexual harassment. So that's important to understand. I want to talk a little bit about conducting an investigation when you've got a complaint about illegal harassment. Before you initiate a formal investigation, make some inquiries. Determine exactly what's occurred. I was involved in a number of these where we just made an inquiry and somebody just said something stupid. Well, it doesn't make it exactly illegal harassment. So find out what's occurred. If you need a formal investigation, who's going to conduct it? I always recommend you have two individuals conducting the investigation. So you have two people, two witnesses who've heard the testimony of other individuals. It's not one against one. I didn't say that. Yes, you did. No, I didn't. No, yes, you did. You've got two people that are conducting the investigation, and they all hear the same thing. Ensure employees involved are available for interviews. This is important because nobody's too busy for this. It's trying to get it done in a timely manner so that you bring the issue to resolution as quickly as possible. Once that's been completed, make sure the victim is not adversely affected with retaliation and the harassment stops and, of course, doesn't recur. That's what you want to be sure. So again, it's about having a timely investigation if there's a need for that. Also, when handling complaints, demonstrate the willingness to hear and objectively discuss the complaint. Don't take it personal. Don't get personal. Understand what's happened and objectively discuss it. It's also important that once a complaint has to, made, it has to be investigated. I can't tell you how many times I heard, I don't want to get anybody in trouble, but no. Once you have that complaint, you have to investigate it. That's important because you don't want to create a history of not paying attention to complaints that were investigated. Tell the employee confidentiality will be respected as much as possible. You have to have that leeway because if there's any kind of physical contact involved, you may have to contact law enforcement. I had a case where the boyfriend beat up the girlfriend. We had to contact law enforcement. And they came by one afternoon as he was leaving the building and said, could you step over here, hands behind your back, you have the right to remain silent. He was charged with assault. So you may have to call law enforcement if there's any kind of physical abuse or physical contact involved. But again, you want to maintain confidentiality. As far as your responsibilities as management goes, again, educating all employees on your company policy and procedures. Supervisors, again, have to report any complaints or incidents they witness. It's not just, well, that's Joe being Joe. He doesn't mean any harm by that. No. Maybe it's time to talk to Joe and tell him that his statements, aren't appreciated. But you can't just let something slide by and not pay attention to it. And of course, retaliation. You do not want to retaliate against or see retaliation against any employee who complains of harassment. Assist with the investigations and discipline. Coax it along. Make sure it's being done in a timely manner. Understand the disciplinary action. Again, is it consistent with what you've done in the past? And of course, make sure all victims are not adversely affected in terms of retaliation, because it can happen. So, in summary, see illegal harassment and all the definitions that we talked about, all those. The key there, pervasive, creating a hostile work environment, intimidating the work environment for a reasonable person. Pervasive, reasonable person. Those are kind of the keys there. And again, on all harassment is illegal, it's still unacceptable. Okay. Okay. Bill, do we have any questions on this segment?
Yeah, there is one, Dennis.
Okay.
When you were talking about I-9,
Yes.
is it correct to assume that that employee has to properly complete an I-9 showing all the requirements
Yeah.
before he can be hired?
Well,
But if that, or let me give you the second part of it. But or are you saying that if I only have one or two employees, the employer does not have to check the immigration status of that employee, or that just means that they won't be fined if they only have one or two?
take the first part. It's the employee's responsibility to provide the documentation. It should be done, it has to be done within 48 hours of their starting employment. Most companies do it as part of their, filling out all their paperwork for W-4s and, emergency contact. They fill out their I-9 on their first day of employment. When they get all their other stuff to do, you fill out the I-9. And again, it has to be put in a separate file. As far as less than 3 employees, you can take the chance, because once you get over 3 employees, then you've got to have the I-9, and maybe you don't have I-9s on your previous 2 employees. I'd get the I-9 filled out. It's a safe harbor, just to have it, to be sure that you don't have any undocumented individuals working for you. You don't want to get caught up in one of those sweeps that we all read about over the past couple of years.
Okay. Thank you.
Else?
No, that's all.
Okay. All right. Let's go on to our 4th segment. Moving right along here. Talking about sexual harassment. While sexual harassment is not required under federal law, I think it's important and essential that members of management know how to recognize it, how to respond to it, and most importantly, how to prevent it. It's going to happen. There's no way you can have 100% surety that you're not going to have sexual harassment. It's going to happen. But again, it's recognizing it, it's responding to it, and doing all you can to prevent it. So it's important that as you train your managers and train and educate your employees, understanding what it is and how it can impact the organization. But again, 100% guarantee, no. Wish you could. Okay, what we'll talk about in this segment. We'll talk about what it is, the importance to prevent it in the workplace. Again, we'll talk about conducting the investigation, a little different twist here. Spend some time on retaliation because this can be very harmful to an employer. And again, the policy and procedure and what your responsibilities are as managers and supervisors. Okay, what is it? Sexual harassment. Unwelcome sexual advances, requests for sexual favors. Again, the verbal, physical contact that affects an individual, unreasonably interferes with his or her work performance or creates that hostile work environment. Interfering with work performance and creating a hostile work environment. That's what's key with sexual harassment, probably more so than it is with just illegal harassment. 2 forms. Quid pro quo, this is simply this for that, something for something. Hostile work environment. Those are the 2 forms of sexual harassment that we're going to talk about. Quid pro quo involves a tangible employment action against the victim. This is usually a supervisor, subordinate type issue because the supervisor or management personnel is the only ones who can give a tangible employment action. Co-workers can't do it. So in exchange for sexual favors, I will hire you, I will give you a raise, I'll give you easy work assignments. There's a tangible employment action presented as part of quid pro quo. Can involve monetary loss, can involve monetary gain, change in job, good or bad. Example, employees denied promotion because she refused to go out with her supervisor and she didn't get a promotion. That is a tangible employment action by a member of management. A hostile work environment. This is speech and conduct. Severe, pervasive, creates an abusive or hostile work environment. Our example here, the male coworker continuously asks the female coworker to meet him after work for a drink. It's continuous, it's pervasive, and it's severe enough to cause some form of sexual harassment. More on hostile work environment. Of course, we see the explicit or suggested items that are emailed, texted, electronically provided, displayed in the workplace, interfering with job performance, and again, creating hostile work environment. I remember years and years ago when I first started in HR, you'd go out to the shipping and receiving dock, and there was every calendar out there. And all these lovely ladies in two-piece bathing suits, wearing a hard hat, of course, on a lift up a big old. You don't see that because you can't see it. So the example, employee text and instant messages her coworkers with sexually explicit jokes and pictures. Someone's going to take offense to that. And again, it can create, hostile work environment and interfere with job performance. Who can commit it? Employees at all levels. You have two employees, you can have a case of sexual harassment. Customers and vendors. Customers can commit it. Your policy should include customers and vendors. Ours did. We had a telephone repair technician who was assigned to our facility. Came in, knew his stuff, did his job. One day, he got a little carried away and made advances towards an administrative assistant. She complained. We investigated, contacted the company. They investigated. He admitted he did it. And we said, he's out of here. Well, but this is his work assignment. I said, not anymore. It's his work assignment. He's out of here. We're going to take action against you because one of your employees committed sexual harassment. And our policy includes that. What are we going to do with him? Not my problem. He was out. And of course, members of the same sex or opposite sex can commit it also. But again, for a vendor, it can be loss of business. For a customer, we like, we love you as a customer, but that's not how you conduct yourself in our facility. Who can be the victim? Of course, the individuals targeted can be the victim. Bystanders. And I've had cases where bystanders, filed a complaint of sexual harassment. All the guys on Monday morning standing around the coffee machine, the vending machine, telling all the jokes, all the stuff. Well, it got pervasive enough that we had a complaint. And we had to tell the guys, clean up your act. Customers or vendors can also be a victim. So you're telling your employees, you don't harass our customers, you don't harass a vendor. A good friend of mine had to fire their purchasing manager because he said, you want our business, then, I expect you to sleep with me. No, and they fired him. But it wasn't me involved in the case. Okay. The importance. Of course, it can have an adverse effect on the entire company. Even though all these, these investigations are confidential, that's about the best kept secret for about a day and a half. People know why so-and-so was let go. And it can have an adverse effect on the entire company. Of course, it's a part of a company's values that you're treating employees with respect and dignity. Again, we all want to be a good place to work. And of course, engaging or condoning, not reporting, and being direct in conflict with those. And of course, the key there too, this is about compliance with Title VII of the Civil Rights Act. That's a federal law, and you don't want to violate that act because you get the EEOC or the Indiana Civil Rights Commission on you, and they have you on their radar screen. There's also liability under federal and state laws. Again, the company is always responsible for harassment by a manager or supervisor, particularly whether it's a tangible employment benefit, and of course that would be considered quid pro quo type of sexual harassment. And in Indiana, the Indiana Civil Rights Commission and the EEOC work hand in hand and basically follow the same guidelines. This is an important point. While it may not be a tangible employment action, there may still be some liability unless, as an employer, you can prove the following. You have exercised reasonable care to prevent and correct. Again, you can't prevent it 100%. It's going to happen. It's a possibility. But you are exercising reasonable care to prevent. You've got the posters up. You've got multiple channels of reporting. You have training on it. You're educating your employees. You're educating your managers. You're taking reasonable care to prevent, and you promptly correct, conducting your investigation in a timely manner, taking timely and decisive disciplinary action whenever it's warranted. Anything from a written warning to termination. You're taking reasonable care to prevent and correcting. Or the employee unreasonably failed to take advantage of your complaint procedure. We had a case where an employee, she went down to the Indiana Civil Rights Commission and complained of sexual harassment. We got the complaint. Legal department's calling me saying, what's happening? Couldn't tell you. Never got a case, never got a complaint. We reported that to the Indiana Civil Rights Commission. They told the employee, you go back to your company and take advantage of your employee's correct policy and procedure. She did. We got the issue resolved, took the appropriate action, and life went on. So again, reasonable care to prevent and correct. If you're doing that, then you can be, you can alleviate some liability. Again, conducting the investigation, much the same as we did with illegal harassment. Take an inquiry, unless, before you start a formal investigation. I did. What happened? What happened? Was it just, somebody saying something stupid, or is there a formal complaint? Make employees available for interview. Have two individuals. Again, here, particularly with sexual harassment, I would encourage you to have a man and a woman involved in the investigation. The confidentiality stays the same. You may have to ensure confidential to all those involved. And then once it's been completed, the employee is not adversely affected, and there's follow-up with the victim and the manager and the supervisor. Okay. Again, when handling complaints, hear and objectively discuss the issue. You may be angry, you may be upset, but you've got to be objective. Again, all complaints, if there's a formal complaint, it's got to be investigated. And again, the confidentiality will be respected as much as possible. Okay, let's talk about retaliation, because sometimes this is the more serious issue in a sexual or illegal harassment complaint. The whole idea of taking retaliation against the company, and unfortunately, I've seen it. Okay. Retaliation is that adverse action taken against an employee because he or she complained or participated in an investigation. The adverse actions, the motion, discipline, all work-related. Taking an adverse action that's work-related as far as what is considered retaliation. Okay, on pages. Okay. As we saw in all the anti-discrimination laws, all of them prohibit employers from taking any action. All the acts we talked about under illegal harassment, Title VII of the Civil Rights Act, all those all have prohibitions against taking adverse action. It's not taking any action that the employee may view as punishment. That's the key here. The employee may view it as punishment for filing the complaint. I know that sounds like, well, we're going to do it. However, you can succeed in a retaliation claim. And here's what's important here. First of all, obviously, it's he or she engaged in protected activity. They complain. Okay, fine, we got the sexual harassment complaint, and we resolve it. They suffered adverse employment action, such as demotion or termination, because of their claim. Okay? And that protected activity and adverse action are linked together. You terminated him or her because they filed a complaint. But to avoid the charge of retaliation, again, going back to documentation, talked about this at the very beginning. It's important to document and get all the information down. Document the reason for the adverse employment action. And that documentation shows no discriminatory reason for the adverse action. We have an attendance issue here. We have a work performance issue here. We've counseled them. We've trained them. We've done all we can. Here's the other part here, particularly coaching your managers and supervisors on conducting business as usual. We address attendance and performance early on. That supervisor just doesn't, turn his or her head because someone came in 10 minutes late. They don't address performance issues. And all of a sudden now they're really a problem. And now it appears they're retaliating because they filed a complaint. Address those issues early on. It's business as usual. You treat that individual the same as every other employee. You got an attendance and tardiness issue. You have a work performance issue. We're putting you on counseling because you can't discipline an employee who's filed a complaint. That employee does not get a free ride. And I've seen it where one employee thought, oh, I can do anything I want because I'll just charge him with retaliation. No, you're not. We're going to take and conduct business as usual. And we did. Life went on. As we talked about in illegal harassment, you have a clearly defined on sexual harassment. Again, the training is there, the information is there. Employees have multiple channels to report a complaint. The policy investigates how an investigation will be completed, and you do it quickly. And with these, again, you can have one policy on bullying, illegal harassment, and sexual harassment, because much of it is the same. That's your choice as an employee. You can combine bullying with workplace violence. I've seen that done, and I've seen illegal and sexual harassment in separate policies. What works best for your organization is how you want to be able to handle that. So again, you have that policy and procedure. As we talked about in illegal harassment, hear and objectively discuss the complaint. It's easy to get emotional, and I've seen managers, senior level management, get very upset about it. My boss's view on sexual harassment was the fact that I had to coach him on the fact that they frown on firing squads these days. It's not acceptable because he would get very upset and say, "I'll take care of it. You just stay off." Again, you've got to report all complaints to a designated member of management, and they have to be looked into. If that complaint has been reported, it has to be investigated. And of course, again, you want to maintain its confidentiality as much as possible, but you can't until it's in order to fully investigate the claim. So in summary, sexual harassment, two things. Unwelcome sexual advances, requests for sexual favors, or other verbal conduct of sexual nature that, again, unreasonably interferes with work, creates a hostile work environment. So that's really what we want to be sure we understand as we come out of this. The two forms, quid pro quo and hostile. Retaliation, adverse action against an employee's complaint. And again, it's illegal and strictly prohibited when you talk about retaliation. So, overall summary of our 4 segments. Disruptive employees. Not dealing with them can really cause some issues if you don't do it in a timely manner. The bullying behavior can lead to illegal harassment. And sexual harassment can have an emotional as well as a financial impact on any employee. And how important education and training are on these issues. And you can go a long way in preventing them from occurring in the future. Any final questions or comments, Bill?
No, Dennis. The question and answer area and the chat area is empty. So
Okay.
I think we're good.
Well, I want to thank you all for your interest and attention. Again, as Bill indicated in the beginning, this presentation will be sent out to each attendee. We hope that you'll take some time to fill out a feedback form that you can get from SCORE. This is important to us in terms of all of our webinars. We'll be giving you the topics and the information you want. And so again, we encourage you to take a few minutes and fill out the survey.
Dennis?
Yeah.
A question just came in.
Yeah.
Is it okay for an employee being harassed to secretly record what's going on?
I'm sorry, I didn't hear the last part of the bill.
Yeah. Is it okay for the employee being harassed to secretly record what's going on
Yes.
as evidence?
Yeah, I mean, they can, you know, if an employee has evidence that things happen, because so many times with harassment, it's he said, she said. I didn't mean anything by that. So anything that they have, substantiate, and make it a legitimate complaint, possible. It gives them more credibility.
Thank you. Are there any other questions for Dennis? Go ahead and continue, Dennis.
Okay. Finally, again, we encourage you to, if you want it, we have all kinds of mentors in all fields ready to assist you. You can find us on our website there. And again, if you have any questions following this webinar or didn't get your question answered, feel free to email me and I'll be happy to respond. It's all yours, Bill.
Thank you, Dennis. And on behalf of Indianapolis SCORE organization, as well as the National SCORE organization, thank you very much for attending today. As noted, you will get copies of the recorded webinar as well as the slides at a future time once we can clean it up. And by all means, look up for mentors for any questions. And we wish you the best and have a great rest of the week. Thank you, Dennis.
Thank you.
You bet.